Criminal law out of the BARBRI commercial outline on page 8, starting section 2, essential elements of crime. A. Elements of a crime. Culpability under Anglo-American criminal law is founded upon certain basic premises that are more or less strictly observed by legislatures and courts when formulating the substantive law of crimes. Consequently, the prosecution is generally required to prove the following elements of a criminal offense. I. Actus reus, guilty act. A. Physical act or unlawful omission. B. Mens rea, guilty mind, a state of mind or intent of the defendant at the time of his act. Concurrence, the physical act and the mental state existed at the same time. And lastly, harmful result and causation. A harmful result caused both factually and proximately by the defendant's act. Virtually all crimes require a physical act and may require some sort of intention. Many crimes also require proof of certain attendant circumstances without which the same act and intent would not be criminal. For example, the crime of stolen property requires that the property received has in fact been stolen. If the defendant receives property, the act that he believes to have been stolen, the mental element, when in fact the property has not been stolen. The absence of this required circumstance renders the defendant not liable for receipt of stolen property. Other crimes require result and causation. Homicide, for example, requires that the victim die and that the defendant's act be the cause of death. B. Physical act. For there to be criminal liability, the defendant must have either performed a voluntary physical act or failed to act under circumstances imposing a legal duty to act. For this purpose, an act is defined as bodily movement. A thought is not an act. Therefore, bad thoughts alone cannot constitute a crime. Note, however, that speech, unlike thought, is an act that can cause liability, i.e., perjury and solicitation. 1. Act must be voluntary. A defendant's act must be voluntary in the sense that it must be a conscious exercise of the will. Rationale. An involuntary act will not be deterred by punishment. The following acts are not considered voluntary and therefore cannot be the basis for criminal liability. We have conduct that is the product of the actor's determination. A shoves B into C with the result that C falls to his death. Can B be held criminally liable for C's death? No. B. Reflexive or convulsive acts. And C. Acts performed while the defendant was either unconscious or asleep unless the defendant knew that she might fall asleep or become unconscious and engaged in dangerous behavior. 2. Omission as an act. Although most crimes are committed by affirmative action rather than non-action, the defendant's failure to act will result in criminal liability provided 3 requirements are satisfied. A. Legal duty to act. See what B and C are before we go into more detail. B is knowledge of facts giving rise to a duty, and C is reasonably possible to perform. So for legal duty to act, the defendant must have a legal duty to act under the circumstances. Rather than a legal duty to act can arise from the following sources: a statute, a contract, or a relationship. Statute, for example, filing an income tax return or reporting an accident. 2, a contract obligating the defendant to act, such as one entered into by a lifeguard or a nurse. 3, the relationship between the defendant and the victim, which may be sufficiently close to create a duty, for example, with children. And examples: a parent has the duty to prevent physical harm to his or her children, or 2, a spouse has the duty to prevent harm to his or her spouse. Really? Anyway, 4, the voluntary assumption of care by the defendant of the victim. Although in general there is no common law duty to help someone in distress, once aid is rendered, the Good Samaritan may be held criminally liable for not satisfying a reasonable standard of care. A, while hiking, while hiking, sees B drowning in a river. Although A is a good swimmer, he takes no steps to save B, who drowns. Was A's failure to act an act upon which liability could be based? No, because A has no duty to act. Note that the answer would be the same even if A recognized B as a person whom he disliked and took great pleasure in watching B drown. 2, if A began to swim out toward B and only after reaching B decided that B was someone not worth saving, A would have violated his duty to act by unreasonably abandoning a rescue effort that was voluntarily undertaken. Hard time believing that. But anyway, 5, creation of peril by the defendant. Example: believing that B can swim, A pushes B into a pool. It becomes apparent that B cannot swim, but A takes no steps to help B. B drowns. Was A's failure to attempt a rescue an act on which liability can be based? Yes. Now, B, knowledge of facts giving rise to duty. As a general rule, the duty to act arises when the defendant is aware of the facts creating the duty to act. For example, the parent must know that his child is drowning before his failure to rescue the child will make him liable. However, in some situations, the law will impose a duty to learn the facts. For example, a lifeguard asleep at his post would still have a legal duty to aid a drowning swimmer. C, reasonably possible to perform. It must be reasonably possible for the defendant to perform the duty or to obtain the help of others in performing it. Example, a parent who is unable to swim is under no duty to jump in the water to attempt to save his drowning child. 3, possession as an act. Criminal statutes that penalize the possession of contraband generally require only that the defendant have control of the item for a long enough period to have an opportunity to terminate the possession. Possession need not be exclusive to one person, and possession also may be constructive, meaning that actual physical control need not be proved when the contraband is located in an area within the defendant's dominion and control. Why are we talking about this? That was 3, and 3 was under the omission as an act. Right, so we're not talking about duty anymore. We're talking about non-action as a crime, and if you possess contraband and you have not just learned that it was in your dominion and control, you have a responsibility to dispose of the contraband within a reasonable, long enough period to have opportunity to terminate the possession. It doesn't say reasonable period. But absent state of mind requirement A, when with regards to the contraband example, absent a state of mind requirement in the statute, the defendant must be aware of his possession of the contraband, but he need not be aware of its illegality or true nature. However, many statutes and the MPC add knowingly state of mind element to possession crimes. Under such statutes, the defendant ordinarily must know the identity or nature of the item possessed. On the other hand, a defendant may not consciously avoid learning the true nature of the item possessed. Knowledge may be inferred from a combination of suspicion and indifference to the truth. C. Mental state. Purpose of mens rea requirement. The reason that mens rea is normally required is to distinguish between inadvertent or accidental acts and acts performed by one with a guilty mind. The latter type of act is more blameworthy and arguably can be deterred. However, in some cases, strict liability crimes, mens rea is not required. 2. Specific intent. If the definition of a crime requires not only the doing of an act, but the doing of it with a specific intent or objective, the crime is a specific intent crime. Significance. A. Under specific intent. It is necessary to identify specific intent for 2 reasons. 1, need for proof, and 2, applicability of certain defenses. So, under need for proof, the existence of a specific intent cannot be conclusively imputed from the mere doing of the act, and the prosecution must produce evidence tending to prove the existence of the specific intent. That said, the manner in which the act was done may provide circumstantial evidence of intent. Example, A shoots B. The fact that A shot B does not show that A had the intent to shoot and kill B. However, if A bought a revolver and ammunition shortly before shooting B, carefully loaded the revolver, took careful aim at B, and fired several times, that evidence may circumstantially prove A's intent to kill B. 2. Applicability of certain defenses. Some defenses, such as voluntary intoxication and unreasonable mistake of fact, apply only to a specific intent crime. B. Enumeration of specific intent crimes. The major specific intent crimes and the intent they require are as follows: solicitation, attempt, conspiracy, first degree premeditated murder, assault, larceny and robbery, burglary, forgery, false pretenses, and embezzlement. Solicitation is the intent to have the person solicited commit the crime. Attempt requires the intent to complete the crime. And conspiracy requires the intent to have the crime completed. First degree premeditated murder, where so defined by statute, requires a premeditated intent to kill. Assault requires an intent to commit a battery. Larceny and robbery requires intent to permanently deprive another of his interest in the property taken. Burglary requires the intent at the time of entry to commit a felony in the dwelling of another. Forgery requires an intent to defraud. False pretenses requires the same, as well as embezzlement. Now 3, malice. Under common law, murder and arson. Although the intents required for the malice crimes, common law murder and arson, sound similar to specific intent, example, the intent to kill for murder, these crimes are not open to the specific intent defenses. The common law created this special mental state category, especially to deny to murder and arson the special intent defenses. To establish malice in these cases, the prosecution need only show that the defendant recklessly disregarded an obvious or high risk that the particular harmful result would occur. General intent, awareness of factors constituting the crime. Generally, all crimes require general intent, which is an awareness of all factors constituting the crime. For example, the defendant must be aware that she is acting in the prescribed way and that any attendant circumstances required by the crime are present. Note that the defendant need not be certain that these attendant circumstances exist. It is sufficient that she is aware of a high likelihood that they exist. Example, to commit the crime of false imprisonment, the defendant must be aware that she is confining a person and that the confinement has not been specifically authorized by law or validly consented to by the person confined. That's wrong. Inference of intent from act. A jury can infer the required general intent merely from the doing of the act. It is not necessary that evidence specifically proving the general intent be offered by the prosecution. Strict liability offenses. A strict liability offense is one that does not require awareness of all of the factors constituting a crime. Generally, the requirement of a state of mind is not abandoned with respect to all elements of the offense, but only the regard to one or some of the elements. The major significance of a strict liability offense is that defenses would negate state of mind, such as mistake of fact, are not available. Identification of strict liability offenses. Strict liability offenses, also known as public welfare offenses, are generally regulatory offenses. For example, offenses that are part of a regulatory scheme that implicate public health or safety. They generally involve a relatively low penalty and are not regarded by the community as involving significant moral impropriety. Note that the mere fact that a statute is silent on the question of mental state does not necessarily mean that the offense is a strict liability offense. If no mental state is expressly required by the statute, the courts may still interpret the statute as requiring some mens rea, especially if the statute appears to be a codification of a traditional common law offense or if the statute imposes a severe penalty. Example, federal legislation prohibits the transfer of firearms not registered under federal law. Is it a defense that the defendant was ignorant of the fact that a firearm was not registered? Held no, because this is a strict liability offense. Awareness of the fact of non-registration is not necessary, although it is necessary that the defendant have been aware of the fact that she was possessing a firearm. Compare. Federal regulation requires registration of any fully automatic machine gun. The statute is silent on the question of mental state and provides a penalty of up to 10 years imprisonment. Held. Defendant may assert as a defense that he was not aware of that the weapon in his possession was automatic. The type of statute and the harsh penalty indicate that Congress did not intend to dispense with the mens rea requirement. Constitutionality B. The majority view is that strict liability offenses are constitutional. Exception. The Supreme Court struck down as a violation of the due process a Los Angeles municipal ordinance imposing strict liability for failure to register as a felon. The key factor in the court's decision was the absence of circumstances which might move one to inquire as to the necessity for registration. Note, the scope of this holding is limited to statutes making criminal the failure to register. Okay, that's not how I remember that case. I remember the case being that notification should have been given if you expect people to conform to the statute. In this description, it says, court's decision was the absence of circumstances which might move one to inquire as to the necessity of registration. And that just wasn't what I took from the case. Nevertheless, Model Penal Code analysis of fault. The Model Penal Code advocates the elimination of the ambiguous common law distinction between the general and specific intent. Instead, the Model Penal Code proposes 4 categories into which the mental component of a criminal offense, i.e., the element of fault, can be characterized, because consistent use of the categories leads to analytical clarity. They have been incorporated into several state criminal codes. They likewise provide a convenient way of analyzing problems on the exam that incorporate statutes. Purposefully, knowingly, and recklessly. When a statute requires that the defendant act purposefully, intentionally, knowingly, or recklessly, a subjective standard is being used. For example, the question is, what was actually going on in the defendant's mind? Purposefully. 1. A person acts purposefully with respect to his conduct when it is his conscious object to engage in certain conduct or cause a certain result, for example, burglary. Knowingly. A person acts knowingly with respect to the nature of his conduct when he is aware that his conduct is of the nature or that certain circumstances exist. He is deemed to be aware of these circumstances when he is aware of a high probability that they exist and deliberately avoids learning the truth. He acts knowingly with respect to the result of his conduct when he knows that his conduct will necessarily or very likely cause such a result. Conduct performed knowingly frequently satisfies the mental state of a statute that requires willful conduct. But note, some criminal statutes define willfulness as requiring that a defendant act knowingly and intentionally. Remember that we're not defining willfulness right now. We're defining knowingly. And since that was long, let's try it again. A person acts knowingly with respect to the nature of his conduct when he is aware that his conduct is of that nature or that certain circumstances exist. He is deemed to be aware of these circumstances when he is aware of the high probability that they exist and deliberately avoids learning the truth. He acts knowingly with respect to the result of his conduct when he knows that his conduct will necessarily or very likely cause such a result. Conduct performed knowingly frequently satisfies the mental state of a statute that requires willful conduct. But note, some criminal statutes define willfulness as requiring that a defendant act knowingly and intentionally. Intentionally isn't part of this section either. We're talking strictly purposely, knowingly, and recklessly. When a statute requires that the defendant act purposefully, which in parentheses we're coining intentionally, knowingly, or recklessly, a subjective standard is being used. For example, the question is what was actually going on in the defendant's mind. Purposefully. A person acts purposefully with respect to his conduct when it is his conscious object to engage in certain conduct or cause a certain result. Example, burglary. Knowingly. A person acts knowingly with respect to the nature of his conduct when he is aware that his conduct is of the nature of or that certain circumstances exist. He is deemed to be aware of these circumstances when he is aware of a high probability that they exist and deliberately avoids learning the truth. He acts knowingly with respect to the result of his conduct when he knows that his conduct will necessarily or very likely cause such a result. Conduct performed knowingly frequently satisfies the mental state of a statute that requires willful conduct. But note, and this is the part in parentheses that's killing me, Some criminal statutes define willfulness as requiring that a defendant act knowingly and intentionally. Sometimes that's how they define willfulness. Willfulness is defined in a great many ways. Anyhow, recklessly is the last one in this Model Penal Code analysis of fault section. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that conditions exist or that a prohibited result will follow, and this disregard constitutes a gross deviation from the standard of care that a reasonable person would exercise in that situation. An act performed recklessly is also performed wantonly. Recklessness requires that the actor take an unjustifiable risk and that he know of and constantly disregard the risk. Mere realization of the risk is not enough. He must know that injury might result. If he knows that it is certain to result, he acts knowingly. Thus, recklessness involves both objective, unjustifiable risk and subjective awareness elements. Negligence is B under Model Penal Code analysis of fault. Why have we separated purposely, knowingly, and recklessly from negligence? And I asked that question in reserve. No further questions. So that's because there's four. there's four analysis of fault under the Model Penal Code. Now let's read this one more time. The Model Penal Code advocates the elimination of the crazy distinction between general and specific intent and proposes four categories into which the mental component of a criminal offense, the element of fault, can be characterized. Because consistent use of these categories leads to analytical clarity, they have been incorporated into several state criminal codes. They likewise provide a convenient way of analyzing problems on the exam that incorporate statutes. So, if I was going to help myself now, I'm going to provide what the professor provided, but like in a different way. So you have specific intent and general intent in the Model Penal Code. And this is all with regard to mental component element. The specific intent and the general intent were under what? The common law. And now the Model Penal Code says it was kind of arbitrary. And they want to break it down now into four different categories as follows. I'm going to read negligence now. A person acts negligently when he fails to be aware of a substantial and unjustifiable risk that circumstances exist or a result will follow, and such failure constitutes a substantial deviation from the standard of care that a reasonable person exercise under the circumstances. To determine whether a person acted negligently, an objective standard is used. However, it is not merely the reasonable person standard that is used in torts. The defendant must have taken a very unreasonable risk in light of the usefulness of his conduct, his knowledge of the facts, and the nature and extent of the harm that may be caused. Example, D held himself out to the public as a doctor even though he was not a licensed physician. He treated a sick woman by wrapping her in kerosene-soaked flannels for 3 days. The woman died. Held, D is guilty of manslaughter. His good intentions were irrelevant. By objective standards, he took an unjustifiable risk. Now, 1 under negligence is a violation of statute or ordinance as evidence of negligence. Violation of a statute, municipal ordinance, or administrative regulation may, as in tort law, be evidence of liability. For example, A, driving in excess of the speed limit, hits and kills B, a pedestrian. A's speeding violation may be admissible as evidence of his negligence in a prosecution for manslaughter. So, I'm gonna break here.